There he is, the Commander-in-Chief of the Economic Freedom Fighters, taking his seat next to his co-accused. Of course, the money involved here relating to that 52 million rand government tender, and some of the money, it is alleged, has been used by Julius Malema to buy a farm as well as a luxury vehicle. We'll find out today whether the judge will today separate these two cases, as you heard that he wants the trial to be separated. That is Julius Malema, and it looks like it's going to start now.
Yes, Mr. President.
As the court pleases, my lord, the court is constituted as the previous day. The representation is the same. The first issue, my lord, that I want to deal with is the absence of accused number 5. I therefore apply for a warrant of arrest against accused number 5. That the warrant against accused number 5 be provisionally suspended until the 24th. That his bail be provisionally forfeited until he makes an explanation to this court. The second issue I'm dealing with, my lord, is continuation of these proceedings in the absence of accused number 5. In view of the fact that accused number 5 is not here, in view of the fact that I've applied that a warrant of arrest to be issued against him, which is suspended until he makes his appearance here, I apply that the court grants or orders that his absence from today until the 24th is authorized by the court. In the circumstances that the proceedings continues in terms of Section 1592, subsection B, sub BB. My lord, the section empowers you to grant the application I'm making. If I may read, Section 1592, it reads, if two or more accused appear jointly at a criminal proceedings end the court at any time after the commencement of the proceedings. Satisfied upon application. In fact, let me script that and read B. Any of the accused is absent from the proceedings, whether under the provisions of subsection 1 or without leave of court. This is the position in this case, my lord. Accused number 5 is absent from these proceedings, and he does not have leave of this court to be absent. The section continues. The court, if it is of the opinion that the proceedings cannot be postponed, and I want to make this point, my lord, the state is not applying for postponement. If it is of the opinion, if it's the opinion of the court that the proceedings cannot be postponed without undue prejudice, embarrassment, or inconvenience to the prosecution or any co-accused or any witness in attendance or subpoena to attend, may sub BB direct that the proceedings be proceeded with in the absence of the concerned accused. My lord, I want to make this this proposition. The proceedings in this trial have duly commenced, and we have commenced by applying for a warrant of arrest for the accused who is absent in these proceedings without leave of court. That is what commenced these proceedings. And we believe it is in the interest of justice that the proceedings continues.
Well, the commencement of the proceedings is stated in subparagraph A. You are relying on B, if I understand you well. A does not talk about commencement, does it? Because when you look at 2, if 2 or more accused appear jointly at criminal proceedings,
yes,
and you move to B, there's no reference to commencement of criminal proceedings, is there?
A it's dealing with when the application is made by the accused.
Yes. That's A, if the court any time after commencement of proceedings satisfied upon application made to it by accused person or his legal representatives. That's A.
Yes.
It talks about commencement of proceedings. But B, you are relying on B. Is
Yes.
that what you are saying?
Yes.
Now B says any of the accused is absent from the proceedings, whether under the provisions of subsection 1 or without leave of the court.
Yes.
That's the section you are relying on.
Yes. The accused is absent without leave of the court. That's what I'm saying. The accused is not here, but he was not granted leave not to be here. And I'm saying this section empowers the court to grant continuation in the absence of this accused. If the court is persuaded that there would be undue prejudice, embarrassment or inconvenience to the prosecution or any of the co-accused or any witness. That is the basis. The basis to grant continuation is that the accused is absent without leave of court, and postponement would occasion undue prejudice, embarrassment, or inconvenience to the prosecution or the co-accused. And we are saying, my Lord, if we continue, those would be obviated. But we must be granted an opportunity to continue in the absence of the accused number 5. That's the application we're making, my Lord. Thank you.
Yes, thank you. Let me hear the first, the representative of number 5, I think. He's directly involved. I will give you an opportunity to address it. Yes.
My Lord, the court would recall from yesterday that the absence of accused number 5 would obviously necessitate the application that we sought yesterday, that the proceedings be postponed in order to allow him to be present in court. But in dealing with the application made by the state, I may as well add my interpretation to the section quoted.
Yes.
My Lord, it is my submission that the state cannot rely on BB in isolation of AA. And I'll show the court why I'm making this submission. And I'll read AA, my Lord. In the case of paragraph A. Now, paragraph A is referring to the circumstances where the proceedings have commenced.
Yes.
And authorize the absence of the accused concerned from the proceedings for a period determined by the court and under conditions which the court may deem fit to impose. From there, going to B, it doesn't say or, it says and. In other words, my interpretation is that B should be read with AA, which refers the court to subsection A. In other words, the issue of the commencement of the proceedings, it's still catered under BB because it is not a provision that is standing alone. It's continuation of what is said in AA. That is why it is said and the end is actually giving the court certain powers to do something, but it refers the court to paragraph A, where the proceedings would have commenced for this application to be valid in court.
Yes. So what is your take? You're saying that AA must be read with BB.
That is correct, sir.
I hear you on that submission. So what do you take about the other parts of the application? For example, that I should authorize a warrant and withhold it. I should declare the bail forfeited provisionally. I want to hear you on those because it affects your client directly.
Those are the procedural steps, and I will have no objection to them.
Okay. So in the end, you say your instructions are to apply for a postponement. Is that what you're saying?
That is correct, sir.
Yes. Okay. Anything else?
That will be all.
Okay. Thank you very much. Mr. Otis.
My Lord, my surname is Hodes, H-O-D-E-S, for the purpose of the record. I'm instructed by two attorneys here, Ian Levitt and John Mahoto, one from Johannesburg, one from local. My Lord, I wish to oppose the application of the state and begin by saying that I'd be remiss in my duties as an officer to this court not to do so. My Lord, My learned friend has asked, he's got a two-founded he rests on two foundations essentially. Firstly, he, on the basis of the absence of accused number 5, asks this court to issue a warrant of arrest and provisionally suspended until the 24th, to provisionally forfeit the bail, and then he asks this court, in the absence of accused number 5, to continue. And I hope to illustrate to your Lordship that this is not legally possible. The beginning, my Lord, starts with the powers of this honourable court. This court is not like a lower court. It's a high court that has a discretion that overrules that of a lower court. But the procedures relating to criminal procedure are governed by the Criminal Procedure Act. There can be no dispute about that, my Lord. So where my learned friend asks your Lordship to issue a warrant, and he says provisionally suspended, the correct term is to hold it over. He's acting, my Lord, in terms of Section 67 of the Criminal Procedure Act. There's no other basis for his application. And this court will in turn be obliged to follow the procedures set out in Section 67 of the Criminal Procedure Act. So what I want to explain with respect to this Honourable Court, or through this Honourable Court to my learned friend, is the procedure going forward. And there can be no dispute, my Lord, that it's governed by the provisions of the Criminal Procedure Act. And if we look at the Act, my Lord, and this is where my learned friend's interpretation falls flat with respect, is we'll see with respect, my Lord, that the Criminal Procedure Act is divided into specific chapters that govern different stages of the proceedings. So if one turns to the beginning of the Act, one will see that the Act, like all Acts, my Lord, it starts with the definitions, and then the starting point, Chapter 1, is the prosecuting authority, which is the title to prosecute, and how it comes about. Chapter 2, search warrants, entering of premises, seizure, forfeiture, and disposal of property connected with offences. It's the procedure leading up to criminal trials, my Lord. Chapter 3 is the ascertainment of bodily features of persons. Chapter 4, methods of securing attendance of accused in court. And then we get to Chapter 5, arrest. Then it's defined in the Act. Chapter 6 deals with summonses. Chapter 7, written notice to appear in court. 8 is admission of guilt. Fine. 9, which will become opposite to this matter, my Lord, is bail. But it's all procedures that are prior to the trial. And one is then told which sections fall into these different chapters, as opposed to bail. Chapter 10 is the release on warning. Chapter 11 is assistance to accused. Chapter 12 is summary trial. 13 is accused, capacity to understand proceedings, mental illness and criminal capacity. Chapter 14 is the charge. And most significantly for our purposes, my Lord, Chapter 15 is the plea. That's the plea proceedings. One knows by way of example that it contains sections 105 to 109. Special pleas, section 106 will fall into that chapter, and that deals with the whole plea procedure. But one can see the process, my Lord. It's from the investigation to the arrest to the appearance in court, including the bail, and then we have the plea. Then we deal with jurisdiction, and we have pleas of guilty, pleas of not guilty that fall under the plea proceedings. And then there's a distinction in chapter 19 and 19 as to pleas between the High Court and the Regional Court. But most significantly, after Chapter 20 being preparatory examination, we have trial before Superior Court. And then, my Lord, we deal with what we're dealing with in this very application, conduct of proceedings. So in other words, Chapter 22, my Lord, which is what we're dealing with here, is entitled Conduct of Proceedings, and it's sections 150 to 178, which would include, with respect, my Lord, section 159, on which my learned friend relies. So it's after the plea proceedings. It doesn't override the plea proceedings. It can never relate back to the plea proceedings. It's the conduct of proceedings, how the trial is run after the plea stage has taken place. So if we turn then to that, your Lordship will see that all the special pleas are dealt with in the previous chapter. Everything relating to pleas in the different courts applies. So when we come to this chapter 22, and your Lordship will see, it deals with the conduct of proceedings. And I'll just go through the headings, my Lord, because the most fundamental principle of interpretation is to place the actual section into the context in which it appears. And your Lordship will see this Chapter 22 starts with Section 150. Prosecutor may address court and adduce evidence. That's how the trial begins. 151, accused may address court and adduce evidence. So we know in practice we have the state's case, then we have the defense case. 152, criminal proceedings to be conducted in open court. 153, circumstances in which criminal proceedings shall not take place in open court. 154, prohibition of publication of certain information relating to criminal proceedings. 155, persons implicated in same offence may be tried together. 156, persons committing separate offences at same time and place may be tried together. 157, opposite to this case, joinder of accused and separation of trials. 158, criminal proceedings to take place in presence of accused. So Section 158 makes it clear that in our courts of law, the proceedings must take place in the presence of the accused. The exceptions, my Lord, appear from 159, and importantly, my Lord, the subsequent amendments to the Act in terms of 159 capital A through to D, which are very recent, my Lord, which show and prove the point that I wish to make. Section 159, which my learned friend relies on, is entitled Circumstances in which criminal proceedings may take place in absence of accused. 1591 makes it clear with respect, my Lord, that it's after the commencement of the trial, and it says in sub 1, if an accused at criminal proceedings conducts himself in a manner which makes the continuance of the proceedings in his absence impracticable, the court may direct that he be removed and that the proceedings continue in his absence. So it's clear that it's after the plea proceedings. It cannot be before, and it specifically says so. It's for the continuance. It's once the proceedings have started. Sub 2, if two or more accused appear jointly, so not appear for the first time or plead, there's no provision. Let me say it out straightforward to your Lordship. There's no procedure in our law for different accused to plead at different stages of any particular trial. There's clear prejudice. There can be no question about it. One cannot say, we're going to start the trial. It encompasses, and I'm going to use the example of this case, my Lord. It encompasses 55 charges. Accused number 5 is only involved in 7 of those charges, being 1, 2, 3, 12, and then it's 36 to 38. So it's only those specific charges. So let's hear all the evidence on the other charges, and in 6 months' time, when we turn to count 1, we'll invite him to come and plead. We cannot do that because it's a trial that's happened in absentia, which our courts do not recognize. To continue with 159, and before I turn to the latter, more recent amendments to 159, 159.2 says, if 2 or more accused appear jointly at criminal proceedings. So it's a subsequent appearance after the plea procedure. It's conduct of proceedings. It's during the proceedings, not prior to. There's no provision made to this occurring before a plea. And in that regard, and I'm issuing a challenge to my learned friend for the state, to identify any one case that's ever been reported in the history of South African law where such a procedure was adopted, that there was a separation and that an accused was subsequently joined later on, or not even a separation, because it says there shouldn't be a separation, where plea proceedings took place in the absence of an accused who was then somehow joined. I don't know where he finds the procedure to do so, at a later stage allowed to plead after the fact and then conduct the proceedings, or even where proceedings occurred in his absence or in the absence of his legal representative, which I expected accused number 5's representative to address, and then he subsequently joined, and there can be any argument that there's no prejudice. So 2, as I've pointed out, says if 2 or more accused appear jointly. So to me, that's a subsequent appearance at criminal proceedings, which is part of this chapter, conduct of proceedings. It cannot be at the plea stage. It says, and A, the court is at any time after the commencement of the proceedings, and that's where we find the catchphrase, satisfied upon application made by an accused. So it's the accused who says, please continue in my absence, I'm not well enough to attend. So he says, by an accused in person or by his representative, 1, that the physical condition of that accused is such that he is unable to attend the proceedings, or that it is undesirable that he should attend the proceedings, or 2, that circumstances relating to the illness or death of a member of the family of that accused make his absence from the proceedings necessary, or, so they're all joined with respect, my Lord. B, any of the accused is absent from the proceedings, whether under the provisions of subsection 1 or without leave of the court. The court, if it is of the opinion that the proceedings cannot be postponed without undue prejudice, embarrassment, or inconvenience to the prosecution, or any co-accused or any witness in attendance or subpoena to attend may, AA, in the case of paragraph A, authorize the absence of the accused concerned from the proceedings for a period determined by the court and on the conditions which the court may deem fit to impose, and BB, direct that the proceedings be proceeded with in the absence of the accused concerned. Now let's pause for a moment, if I may, my Lord. Accused number 5 says you cannot invoke section 159. The way I read section 159, it's an application by the accused to be excused. So the way I read 159.1, it's where the accused doesn't behave, the court continues in his absence with his legal representative present. 159.2 is where by virtue of some problem that the accused has, he doesn't appear before the court. And it continues, it says that the proceedings cannot be postponed. So in B it says any of the accused is absent from the proceedings, whether under the provisions of sub 1 or without the leave of the court. The court, if it is of the opinion that the proceedings cannot be postponed without undue prejudice, embarrassment, or inconvenience to the prosecution or any co-accused or any witness in attendance or subpoena to attend, may, AA, in the case of paragraph A, authorize the absence of the accused concerned from the proceedings for a period determined by the court and the conditions which the court may deem fit to impose, and BB, direct that the proceedings be proceeded with in the absence of the accused concerned. It's unnecessary for me to address 3 and 4 with respect, my Lord, because it's not apposite and it's not before your Lordship. But just as I had alluded to in the beginning, my Lord, section 159, capital A, is postponement of certain criminal proceedings through audio-visual link. So that facilitates, my Lord, where the accused or suspects aren't brought from the prison. It's a postponement in the proceedings without them having to come to court, and you have a video and audio link which facilitates, for the purpose of the conduct of the trial, that proceedings continue. 159, capital B, is requirements for either audio-visual appearance by accused person. 159, capital C, is technical requirements for use of audio-visual link. 159D, protection of communication between accused person and legal representative. And then if we see 160 is procedure at criminal proceedings where accused is absent, which deals, and your Lordship will see, that it deals with the circumstances that I've depicted before your Lordship. So it's specific, but one will not find there, my Lord, any provision in section 160 to allow an accused person to plead to charges long after the commencement of a trial, or at any stage after the commencement of a trial. It doesn't exist. It doesn't happen in our law. So, my Lord, we have to now apply, with respect, those principles to this, to the facts of this case. The facts of this case, my Lord, start as follows. The allegations in the indictment relate back to October 2009. Count 3 refers to the 2nd and 4th of October 2009. Against that background, my Lord, we have an arrest that took place of the accused on the 26th of September 2012. What then happened, my Lord, is that the state, at their request, as they're entitled to, and it's entirely within their discretion, and let me make that absolutely clear, I'm of the view, my Lord, that that's a decision that rests only with the state, and they cannot be compelled to separate. When it comes to the charges, the state then separated the trials, and there were 2 trials that thereafter ran independently. One, if I may, I refer to as being the Oceanside trial, which is referred to in these charges, my Lord, and the other being this trial, which we can refer to for convenience as the on-point trial. There were numerous interactions between the state, but eventually, my Lord, the trial against Oceanside and 3 other former co-accused, being Helen Moreira, Selby Montata, and a certain other Mr. Montata, commenced on the 14th of August 2013. What happened, my Lord, is that the trial ran, there were charges withdrawn against the one accused at the police stage.
My Lord, I am not sure what my learned friend is trying to address here. He's out of the application that is before you. He's now telling you about a case that took place somewhere else, which has got no relevance to the application that is before you.
I understand the point he's making is that there was a separation before.
Thank
You recall that yesterday we raised the possibility of a separation.
Yes.
and I'm alive to the fact that the prosecution is not willing to separate. He's addressing me on that point.
But he has himself said the separation, as he alluded to, is at the discretion of the state, not his.
Yes, I understand that.
Thank you, my Lord. In response to my learned friend, to the extent that it might be necessary, I need to sketch the background. Your Lordship wasn't present, nor was my learned friend for that matter, despite his comments next to me, which I'll ignore. So the point that I'm making, my Lord, is in order to determine the way forward, it's very important and material that your Lordship knows the background to this application, and it will also pave the way for what I say is the procedure to be followed going forward, which doesn't lie in section 159. I never restricted him in his address, and I believe that I have a duty as an officer of this Honourable Court to do so. So the important...
You can outline the...
I'll do it very briefly.
Yes, the historical background, but do not go into the merits of what transpired in that.
As your Lordship pleases.
Yes.
My Lord, I can even stop at that, my Lord, and say, that's the background that led to several postponements of this matter. But what becomes crucial, my Lord, and I don't believe my learned friend is going to interrupt me now, because it suits his case, is that on several occasions, and I say it as an officer of the court, my Lord, this matter, this trial was postponed at the request of accused number 5. Accused number 5 appointed, not my learned friend, and I attribute no blame to him. We appointed a counsel from Bloemfontein by the name of Nell, who engaged on several occasions in correspondence with the state to say, these are the dates that I will be available to attend to this trial. And that's how we got to yesterday's date, my Lord. It was at the request of accused number 5's representative, Advocate Nell from the Bloemfontein Bar, whom I don't know, my Lord. And the matter was postponed to yesterday at his specific request. It was a long postponement, my Lord. It dates back a year. Matter had been set down for September 2014. It couldn't run, my Lord, because there was problems with the availability of his representative. It was then postponed, my Lord, to yesterday to accommodate Mr. Nell. Now, I'm not here to criticize a colleague or anything, but ordinarily, Mr. Nell should be here once the date was specifically arranged with him at his request and to accommodate him. So it was done for his convenience. Let's start there. The point then becomes, my Lord, if we look at what's causing the delay now, the blame lies once again with respect, not with the state, it lies with accused number 5. He's not here. So, as I said earlier, my Lord, when an accused fails to appear, the court is, with respect, if not compelled, then at least obliged to have regard to the provisions of section 67, which fit, as I've tried to illustrate earlier, under the bail provisions. And section 67 specifically is entitled Failure of Accused on Bail to Appear. With its common cause, I don't believe there could be any dispute, my Lord, that accused number 5 is on bail. And it's a short section made up of 3 subsections, which I beg leave to refer to your Lordship. It says, if an accused is released on bail, A, fails to appear at the place and on the date and at the time appointed for his trial, or to which the proceedings relating to the offence in respect of which the accused is released on bail or adjourned, or B, fails to remain in attendance at such trial or at such proceedings, the court before which the matter is pending shall declare the bail provisionally cancelled and the bail money provisionally forfeited to the state. So that's the order that my learned friend ought to have asked for. That is, bail is provisionally cancelled, the bail money is provisionally forfeited to the state, and issue a warrant for the arrest of the accused. So you issue a warrant. You cannot provisionally issue a warrant. You issue it, but you hold it over. It says 2A, if the accused appears before court within 14 days of the issue under subsection 1 of the warrant of arrest, the court shall confirm the provisional cancellation of the bail and the provisional forfeiture of the bail money, unless the accused satisfies the court that his failure under subsection 1 to appear or to remain in attendance was not due to fault on his part. B, if the accused satisfies the court that his failure was not due to fault on his part, the provisional cancellation of the bail and the provisional forfeiture of the bail money shall lapse. C, if the accused does not appear before court within 14 days of the issue under subsection 1 of the warrant of arrest, or within such extended period as the court may on good cause determine, excuse me, the provisional cancellation of the bail and the provisional forfeiture of the bail money shall become final. 3, the court may receive such evidence as it may consider necessary to satisfy itself that the accused has under subsection 1 failed to appear or failed to remain in attendance, and such evidence shall be recorded. So the important point, my Lord, is that this envisages an inquiry in the future to be held excuse me, between the state and accused number 5. The other accused have no involvement in the matter. They don't even have to be present. It's the state says, please, court, inquire as to why accused number 5 wasn't here. It's only going to delay the proceedings further. We have a medical certificate here. It was issued on the 31st of July for this matter. And I envisage with respect that there's going to be an inquiry, and it's going to take a long time to resolve. Does he have a justification for not appearing? That inquiry takes place in the absence of these accused. So one asks oneself, on a practical basis, how do we go forward in this matter against this background of the arrests and allegations dating back several years? And in my respectful submission, and I've alluded to this previously, the answer lies in section 342, capital A. And that gives this court that inherent discretion that I referred to previously. And your Lordship will see that this 342, capital A, relates to all types of proceedings because it falls under chapter 33, which is the general provisions. So it governs everything and all the powers that the court has in relation to proceedings, in relation to bail, in relation to everything. And 342A deals with unreasonable delays in trials. And this is what's happened here with respect, my Lord. We've had accused number 5 who's delayed the proceedings and is now not present. So the most apposite, the most applicable section is 342A. Now we look to my original argument prior to pleading or post-pleading, and the answer is clear, yes. It's clear that it's in the affirmative. And where do I get the authority for that, my Lord? It's in 342A sub 3. And this guides the way forward. And it provides as follows, my Lord. It gives your Lordship lots of powers, but not to separate with respect, my Lord. And that's why I do agree with my learned friend that this court cannot compel anybody to separate because there's an impact on the merits of the trial going forward. 342A3 provides as follows. If the court finds that the completion of the proceedings has been delayed unreasonably, the court may issue any such order as it deems fit in order to eliminate the delay and any prejudice arising from it, or to prevent further delay or prejudice, including an order A, refusing further postponement of the proceedings, B, granting a postponement subject to any such conditions as the court may determine. Then the one that I submit is applicable here, my Lord, 342A sub 3 sub C, which provides, where the accused has not yet pleaded to the charge, that the case be struck off the roll and the prosecution not be resumed or instituted de novo without the written instruction of the Attorney General, and from the interpretation, no, that's the Director of Public Prosecution. And then we see the distinction, my Lord, as to what happens where the accused have pleaded. Indeed, he says, where the accused has pleaded to the charge and the state or the defense, as the case may be, is unable to proceed with the case or refuses to do so, that the proceedings be continued and disposed of as if the case for the prosecution or the defense, as the case may be, has been closed. So your Lordship has wide powers. In a trial that's commenced, your Lordship can close either of the cases because of non-compliance, but most significantly, my Lord, and that's what appears here, where this court finds that the completion of the proceedings is being delayed, for whatever reason, I don't blame the state, my Lord, I clearly don't, but they take a view that they're not going to separate, they're not going to postpone, they put the court in a bind, and the court has this power now to say, right, and I'm going to make the proposal, and that will be my argument. The case against these accused persons be struck off the roll, get an order to resume if necessary, and most significantly, the court can then proceed in the inquiry against accused number 5 in due course to determine whether he was justified in not appearing, what should happen to his bail. Because I envisage, against the history of this matter, we've had these long delays, that's going to take months, if not years. Already we have a certificate that takes us forward 3 weeks. It doesn't give an undertaking that he'll be present or better, but then the court, through the prosecution, can monitor the process. The court can then ensure that the proceedings proceed against accused number 5, the court can hold the Section 67 inquiry, determine what happened, and move forward, making any rulings going forward without prejudicing the state by saying to them, state, you have to separate, or you have to do this, you have to do that. The state then decides, and the state, just as I've said, cannot be compelled to separate. It also retains the discretion to join. So once all of these inquiries against accused number 5, for his failure to appear, for his failure of his counsel to appear, whatever the case might be, the state can then decide, right, we're now proceeding, we're going to join the former co-accused back to the proceedings because we're going to set it down for trial. And I'm prepared to give an undertaking that if that's the case and they say to us, please can we arrange a trial date to speed up the process, we would arrange a trial date within reasonable negotiation and go forward to the trial. But to me, with respect, and as an officer of the court, I do not believe that Section 159 can be applied in any proceedings in which the accused haven't pleaded. I also believe, with respect, that this case is far from over in relation to accused number 5. Section 67 has to be imposed. My learned friend has started the proceeding by asking for a warrant of arrest that be provisionally suspended until the 24th. I say held over, not provisionally suspended. He's also requested that the bail be provisionally forfeited until he makes an explanation to this court. That's Section 67 with respect, and I would submit with respect, my Lord, that that's the way forward. I have no further address unless I can be of assistance to this court in any particular way. Safe to point out, my Lord, that the prejudice to these accused that are before the court is almost incalculable, my Lord. They've now prepared for a trial that was scheduled to take place over the next 6 weeks for the entire term, for that matter, because I gave an undertaking, which I honored, my Lord, to give away a case which will appear from the record to the current judge president of this division. I said I had been booked, because in Johannesburg we get booked for trials long in advance, for a trial, and I was asked to facilitate that somebody else does that trial, and I handed it over to a colleague of mine, hoping that this matter would run to conclusion, and I didn't want to prejudice anybody else. That was my ethical obligation that I met. So now, if one works out the costs involved, the personal anguish, which are all factors that one takes into account in the Section 342, capital A, determination of the way forward, it is my respectful submission, my Lord, that a proper case has been made up for this court to make an order in terms of 342, capital A, sub 3, sub C, which would then do justice to all the parties before this honourable court, including the state, my Lord.
Well, on that submission of 342, the effect of it is, in practical terms, if I order that the matter be struck from the roll, there's no guarantee that it will not resurface. In other words, the accused may be called again to stand trial sometime, perhaps early next year.
Yes, my Lord, but that...
Just before you respond, you have raised concerns about the delay in this matter. Now, won't that have the effect of just delaying the trial for the accused? Because if they are going to go now, only to be charged again in January next year, from 2013 or 2012 to 2016, isn't that prejudicial to the accused?
With respect, no, my Lord, and I'll explain why.
Yes.
If your Lordship follows the Section 67 route, which I submit to your Lordship is obliged to follow, these accused are further prejudiced in having to appear all the time. Let that all be resolved, and then let a trial date be set with the accused, and it gives the state the time to consider, do they actually want to go ahead at the end of the day? Because that delay that your Lordship is referring to is inevitable. There's nothing that you can do to avoid this inquiry. You have an accused who never appeared. It was a term of his bail that he had to appear. That inquiry has to take place regardless. Why put these accused to the extra expense of awaiting that outcome with all the appearances in the interim? Rather, withdraw the charge, that the state pursue accused number 5, do what they have to do to accused number 5, and then say, please, let's arrange a trial that, as we've always done historically. We've never been the cause of the delays in this matter. We've always attended court. We've done everything within our power to comply. Why should we now be prejudiced on account of somebody else, and where the state takes this attitude that they're not prepared to separate and pursue us separately. We will say we're prepared to go ahead separately. We're prepared to accommodate the court and the state in any possible way. It would be unfair to then belabor them with these additional expenses and the anguish of a pending trial. Rather get your house in order as to accused number 5, what you want to do with accused number 5, and then come back to us so that this matter can proceed. And I don't act for accused number 4, but 1, 2, 3, and 4 historically, and the record will reflect them, our learned friend will confirm, have always been present in court since the bail proceedings and have never ever been the cause of the delays in this matter.
Yes, thank you. Yes, Mr.
Lord, on behalf of Mr. Malema, let me make the point outright that a postponement presumes the recovery of accused number 5, and it does seem to be a somewhat complicated malady that he has, and it presumes that the charges will proceed on the same charge sheet with the same evidence, and it simply waits for a recovery of accused number 5. On that presumption, there's no certainty whatsoever. I agree that in the final analysis, and for some of the reasons that Mr. Hodes has put forward, there should be an order in terms of 342A3C. But let me put things into perspective as to where we are. My first function is to assure your Lordship we would like to proceed with the matter. We have suggested to the state that they apply for a separation. My client wishes to have his day, or his term as it would be, in court, and he is confident of an acquittal. And against that context, one must regard his fair trial rights. The prejudice to him is enormous. He has put together a legal team comprising myself and 2 attorneys. We've reserved ourselves for 6 weeks of trial. Tremendous effort has been made to read the many volumes that you see there, Your Lordship. That's the docket you're looking at. We've had to read it. We've had to prepare cross-examination. We committed in our diaries at considerable expense to the client for 6 weeks or more of trial. My client is like any other person in South Africa. He's just a member of South African society. And as such, he's entitled to the protection of the Constitution, so hard fought for by many people in this room. He's got a family. He has a job. He has a function in society. He happens to be a member of Parliament, and he happens to be a leader of a party, but he claims no special preference. He just asks for the rights of a member of society. He wants his trial over with, or alternatively, he wants to go back to his function in his family and in his society and in Parliament, because that happens to be his job, as important as anyone else's job. He asks for no special favors. He just wants what any member of society is entitled to do under the Constitution. And that is not to have an interminable sword of Damocles hanging over his head without the resolution of a trial, which he's happy to go through, or the withdrawal of the charge and or a striking off of the roll, same thing, and the state to reconvene, reconstitute their thinking, relook at their charge sheet, decide whether accused number 5, who features in these charges, is going to be part of the future of the trial. And if it is all resolved by the date by which your Lordship would have postponed the matter to, then so be it. But if it is not, then a postponement of the matter would have kept that sword hanging over my client without any benefit whatsoever. So the obvious solution would have been for the state to apply for a separation of trials. But they refused to do it. And it must be absolutely clear, a separation of trials would have us starting this trial within half an hour of your Lordship's judgment, and we would run and complete this trial. No one is avoiding this trial. But if they will not apply for a separation, then your Lordship must strike it in fairness, so that clarity can be obtained in future, and the minimum inconvenience to these accused, and in particular my client, on whose behalf I speak. Our only interest in this matter is, one, to have a trial continue, or alternatively to bring it to a speedy end, even if it's only for the time being until great clarity is obtained in the future. But what we cannot contemplate, my Lord, is entering into an irregular procedure. Now, my learned friend Mr. Hodes has analysed the procedure, and I will do now so in very abbreviated form, because I don't wish to repeat an argument, he has placed into perspective the place where Section 159 falls. And it is after plea. You cannot start a trial without the accused present and pleading. And this is manifest from a reading not only of the context of Section 159 in the Criminal Procedure Act, but from the context as a whole, the place where it comes, just after separation, well after plea. But the Section 159.2, which my learned friend relies on, says, if two or more accused appear jointly at criminal proceedings. So they have to appear. They have to be here. And the court is at any time after the commencement of the proceedings satisfied that physical condition and so on. But the key word, as was pointed out earlier, is Section 159.2 has got two very important component words. If two or more accused appear, so they have to appear jointly at criminal proceedings, and then comes paragraph A, then comes paragraph B. Now my learned friend, Mr. Laka, would leap to paragraph B, and he says that you can say that if any of the accused is absent from the proceedings, whether under the provisions of one or without the leave of the court can, if it is of the opinion that the proceedings cannot be postponed without undue prejudice, embarrassment, or inconvenience, or any co-accused or any witness in attendance, may direct that the proceedings be proceeded with in the absence of the accused concerned. But subparagraphs A, B, all come linked with the word, linked to the word and. So the first part is two or more accused persons must appear. And then what my learned friend wishes to rely on, B. But he doesn't have them appearing. And why does it say appear? Because in the context of the Criminal Procedure Act, they must already have pleaded. They will either be represented or they will have got legal aid. And someone would be here to represent them if they're not here. Let us look at the consequences if my learned friend is successful in starting this trial with accused number 5, still an accused, but not represented, because we're told that his legal representative will not remain, and not having pleaded. Your Lordship will have no plea and no plea explanation. The witnesses will come and go, and they will not be cross-examined by accused number 5. If he comes at a later stage, speaking highly theoretically, he may come and say, sorry, I was ill, I intend to plead guilty. Then your Lordship, under the Criminal Procedure Act, a different provision, would have to convict him on his plea of guilty, and the trial would have to start de novo against the rest of the accused, because your Lordship would then become functus in this trial. If we were here today and one of them pleaded guilty, your Lordship would convict those and another judge would hear the balance of the trial. We would enter into chaos. If he arrives here after 3 weeks and says, sorry, I'm so late, yes, thank you, will you recall all the witnesses that I can cross-examine them? Then we've doubled the length of the trial. My learned friend does not comprehend the mayhem and the irregularity that he is inviting into your court. We will end up in the Supreme Court of Appeal, set aside for an irregular process, and the state will no doubt run for the hills in terms of responsibility for launching us into this process. So my client, Mr. Malema, does not wish to avoid a trial. He wants a trial. The only way is a separation. But if the state won't separate, they can't do a 159 because that's irregular. And we can't advise him as officers of the court to participate in an irregular proceeding. He will have wasted his money. He will be in an unfair trial, which will have to be restarted, and the restart will be unfair. In any event, it appears that Section 159 has got to be predicated upon an application brought in an appropriate manner. Section 157, of course, is available. And when you've dealt with Section 159, we can bring an application for a separation, which we would intend to do, if necessary, under Section 157. But let's focus on the present. The present position is, after an enormous delay, an enormous expense, with the state refusing to separate trials, they're wishing to launch an irregular and unlawful procedure, which our clients can't have a party to. We do not want a postponement, because what would that mean? I've sketched that in the opening part of what I said. We don't know when accused number 5 is going to reappear, at what state of health, what the charges would look like if he never comes back. So to strike the matter from the roll establishes a new platform. There's no certainty that we will be charged. There's no certainty that we will be charged in the same way. There will be no certainty that the charges will be as extensive as they are now if there's no accused number 5 on the horizon. The entire presumption that he will just be here in 3 weeks is not one that anyone can rely on. So, although it is not the state's fault that accused number 5 is here, it's also not our fault, my lord. And we are ready, willing, and raring to go. The state says, I won't separate. And there's no good reason in all the background circumstances for the state not to separate. So what are they doing? They're in effect applying for a postponement, which they don't really dare do, the state is, by suggesting an irregular procedure as a crutch to pretend that they want to go on. The Lordship cannot allow Section 159 to be used. It would launch us into a world of chaos. And we therefore would ask for a Section 342(3)(a) C order as sketched by Mr. Holmes. Thank you.
Shortly for that.
We can adjourn for tea, my lord.
Yeah.
Then we will reply. I'm going to be brief anyway. When we come back, it's not going to be long. But we can take tea.
We'll adjourn and come back.
This is not a road, it's an invitation. This is not driving, this is carving. These aren't bad conditions, because there's no such thing. Okay.
No, brother. Ring. Sure. They're not going to carry it. Unfortunately. Unfortunately.
September 2012.
And remember, we at 4. Go sort your things out. Yeah. But they are considering that we are not at 4. Go receive.
Yeah.
Get 3C.
Yeah, get 3C.
Struck off.
But read it from here.
Resumed. I think there should be an inquiry because then we need to check or no. There was a delay which was unreasonable.
No, there is. Okay. I think we are did that one. Yeah, but then whose fault is it? It's not the fault of any of the parties. So it's number 5.